the ICJ 2002 Arrest Warrant case, formerly known as Arrest Warrant of 11th April 2000, stands as a landmark judgment delivered by the International Court of Justice on February 14th. 2002, addressing fundamental principles of immunity under customary international law. Decided on February 14th, 2002, this pivotal case examined the critical issue of immunity and inviolability enjoyed by incumbent foreign ministers, clarifying their protection from criminal jurisdiction in foreign states under customary international law. On April 11th, 2000, a Belgian investigating judge at the Tribunal de Première Instance de Brussels issued an international arrest warrant in absentia against Abdoulaye Yerodia Ndombasi, who was at that time the incumbent foreign minister of the Democratic Republic of the Congo. This warrant was issued under Belgian domestic law, specifically Belgium's 1993 to 1999 laws enabling universal jurisdiction, alleging grave breaches of the 1949 Geneva Conventions, their additional protocols 1 and the 2 of 1977, and crimes against humanity. In particular, it accused him of incitement to racial hatred and xenophobia linked to events in 1998 to 1999, and the warrant was served via Interpol on September 15th and 18th, 2000, after being transmitted to relevant authorities, including those in the DRC. On October 17, 2000, the Democratic Republic of the Congo initiated proceedings at the ICJ, arguing that Belgium had violated international law through the issuance and international circulation of the arrest warrant against its serving foreign minister. The DRC specifically requested the annulment of the warrant issued on April 11, 2000, and a declaration that Belgium breached customary international law on the absolute inviolability and immunity from criminal process of incumbent foreign ministers. Additionally, the DRC claimed a violation of sovereign equality under Article 2 of the UN Charter and sought provisional measures under Article 41 of the ICJ statute to suspend the warrant's effects and prevent further circulation. During the provisional measures hearings on October 29, 2000, Belgium raised preliminary objections, contending that the ICJ lacked jurisdiction and that the Congo's application was inadmissible. Belgium further argued that the case was moot because Abdoulaye Yerodia Ndombasi had been replaced as foreign minister on September 27, 2000, asserting that the dispute now only concerned a former minister without incumbent immunity. The ICJ conducted oral hearings on these preliminary objections from November 15th to 19th, 2001, thoroughly addressing questions of jurisdiction based on the DRC's Article 36 declaration and Belgium's forum prorogatum, admissibility, and mootness. Crucially, the court distinguished rules on the national jurisdiction of states from rules of jurisdictional immunities, emphasizing that the existence of jurisdiction does not negate immunity and that immunity does not equate to impunity. The ICJ affirmed that an incumbent minister for foreign affairs enjoys full criminal immunity and inviolability while abroad, a protection rooted in customary international law, comparable to that of heads of state or diplomatic agents. This immunity applies without distinction between official and private acts, or between acts committed before or during the term of office, extending even to serious international crimes such as war crimes or crimes against humanity. The court found no exception in customary international law permitting the removal of an incumbent foreign minister's immunity before the national courts of another state, regardless of the gravity of the alleged offences. Consequently, Belgium's issuance of the arrest warrant on April 11, 2000, and its subsequent international circulation constituted a breach of Belgium's obligations toward the Democratic Republic of the Congo under international law. In its ruling, the ICJ stated that its findings on these violations constituted an appropriate form of satisfaction for the moral injury inflicted upon the Congo by Belgium's actions. Nevertheless, the court determined that mere satisfaction was insufficient, as the arrest warrant continued to exist and potentially exert effects beyond the judgment. Therefore, Belgium was ordered to, by its own means, cancel the arrest warrant and notify all authorities to whom it had been circulated of this cancellation. The ICJ explicitly clarified that it could not pronounce on any obligations of third states regarding the warrant, as the dispute was strictly bilateral between the DRC and Belgium. By a decisive 15-1 majority, the court rejected Belgium's preliminary objections concerning jurisdiction, mootness, and admissibility. With a 13-3 vote, the court held that the issuance and circulation of the warrant violated Belgium's obligations by disregarding the incumbent foreign minister's criminal immunity and inviolability. Finally, by a 10-6 majority, Belgium was mandated to cancel the warrant and inform relevant authorities without prescribing specific methods or imposing effects on third states. Ultimately, the case underscored the delicate yet essential balance between the exercise of national jurisdiction and the imperatives of international diplomatic relations and sovereign equality.